This is a case that's been bounced around back and forth throughout the court system.
And today, the Supreme Court has answered that question by a vote of 6-3.
Justice's ruling this morning, it conflicts with the Second Amendment's right to bear arms.
Everybody has a right if they're a responsible adult.
Firearm confiscation. Without a warrant, what if police could walk into your home, take your firearms, and leave no warrant, no arrest, no permission? It sounds like something out of a dystopian novel, but it's not. It's the legal battle unfolding right now at the United States Supreme Court. In the landmark case Caniglia versus Strom, the court ruled 9-0 that warrantless home entry and gun seizures violate the Constitution. That was supposed to be the end of it. But now a new case versus. Montana is aiming to change that using civil legal arguments and public safety loopholes to justify bypassing your Fourth Amendment rights. What's at stake? Your home, your privacy, and your firearms. If you believe in your rights, hit that subscribe button, tap like, and stay through to the end. What you're about to learn could affect every gun owner in America. Chapter 1. The battle begins in Montana. The Supreme Court is once again stepping into dangerous territory where the future of our rights could shift overnight. Case versus Montana challenges the boundaries of law enforcement power and the sanctity of the home, igniting a national debate about privacy and government overreach. The case involves Trevor Case, whose home was entered by police without a warrant. Officers claimed they feared a possible shootout based on vague statements from his ex-girlfriend. After waiting outside for 40 minutes, police entered through an unlocked door. Trevor was shot after allegedly being seen in a closet with a black object. The incident raised questions about probable cause and emergency entry standards. This is not just about one man in Montana, it is about all of us. If the Supreme Court sides with the state, it could normalize home invasions under loose claims of emergency, affecting every American household. Chapter 2. From Caniglia to Case. The Case versus Montana challenge does not come out of nowhere. It builds directly on a powerful precedent, Caniglia versus Strom, where the Supreme Court unanimously rejected warrantless firearm seizures using the community caretaking doctrine. But the Case decision could expand or narrow that protection. In Caniglia, police entered a home and took firearms after a wellness check without a warrant. The Supreme Court ruled 9-0 that this violated the Fourth Amendment. Case versus Montana seeks to apply that same ruling to a more violent and complex situation. But the state of Montana is pushing for a broader exception under emergency aid. The court must now decide how far Caniglia's protection actually goes. This is where legal precedent gets tested. One wrong interpretation, and the unanimous victory from Caniglia could be watered down or redefined beyond recognition. Chapter 3. What really happened that night? To understand why this case could reshape the Fourth Amendment, we need to look closely at the events that unfolded on the night Trevor Case was shot. It started with a phone call, not from Trevor, but from his ex-girlfriend, who told police she had a vague, uneasy feeling about a recent conversation. She could not recall any specific threats or details, just a general fear, and that alone triggered a law enforcement response. 4 officers arrived at Trevor's home and began surveying the property from outside. They looked through the windows but did not see any signs of immediate danger or disturbance. One officer noticed a holstered handgun and a notepad inside, but nothing else alarming. For 40 minutes, they knocked on the doors, called out Trevor's name, and used flashlights to look in with no response. Eventually, despite the lack of clear evidence of a threat, the officers entered through an unlocked front door. Once inside, they moved upstairs where one officer saw a curtain move and immediately fired into the closet. Trevor was hit in the arm and abdomen. He had not said a word. No weapon had been raised. The officers later claimed they believed he might be holding a black object, but Trevor's attorneys argue the shot was fired in less than half a second too fast for any real threat to have been confirmed. The officer himself admitted on scene that he just let one fly after seeing movement. This raises the central legal question: was this a justified emergency response or an unconstitutional home invasion with the use of deadly force? The court is now tasked with deciding whether feelings, hunches, and vague fears can ever replace facts, warrants, and probable cause. Chapter 4. The lower courts failed to protect. Before reaching the Supreme Court, Trevor's case was heard and rejected by lower courts, including a close 4-3 split decision at the Montana Supreme Court. That rejection set the stage for national attention. The trial courts ruled the warrantless entry was justified under emergency aid. Trevor argued it violated his Fourth Amendment rights and should suppress the evidence. The Montana Supreme Court narrowly upheld the police action. The slim margin revealed deep legal disagreement about what qualifies as an emergency. This split gave the U.S. Supreme Court reason to review the case directly. When nearly half of a state's top court believes your rights were violated, it signals a major constitutional crisis worth national attention. Chapter 5. Emergency Aid or Backdoor Loophole. At the heart of this case is a dangerous legal concept, the emergency aid exception. While it allows police to respond to immediate threats, it is now being used as a justification for entering homes without clear probable cause. Montana argues the emergency aid exception only requires reasonableness, not probable cause. The Trump administration supports this, saying probable cause applies only to warrants. Trevor's legal team rejects this, calling it vague and ripe for abuse. They argue that even emergency entries must be held to the probable cause standard. They warn that reasonableness is too subjective and opens the door for overreach. This is not just legal theory. If the Supreme Court lowers the standard for home entry, police across the country could bypass your front door, all in the name of vague emergencies. Chapter 6. The fight over probable cause. The core of the Supreme Court's decision hinges on this question. Does law enforcement need probable cause to enter your home in an emergency, or just a vague sense that something might be wrong? That distinction could change the meaning of the Fourth Amendment forever. Trevor's lawyers argue that probable cause must be the baseline, even in emergencies. They say a new, undefined reasonableness test is too vague and too easily abused. Even the Trump DOJ and the state of Montana cannot agree on how to define it. Probable cause is a clear legal standard, but reasonableness invites chaos. The court's ruling could determine whether clarity or confusion governs home searches. This case is not about blocking real emergencies. It's about preventing vague fears from becoming legal excuses to invade your home without evidence or a warrant. Chapter 7. The Trump administration weighs in. In a surprise twist, the Trump administration has asked to join the oral arguments, supporting Montana's side. Their involvement raises the stakes, not just legally but politically. The Trump DOJ argues emergency aid should be judged by reasonableness, not probable cause. They believe requiring probable cause could slow down life-saving police action. Their argument is that warrantless searches are already exempt from the probable cause rule. Critics say this opens the door to unchecked government power. The Supreme Court has agreed to let the Trump team participate in the hearing. This move signals that even a conservative administration sees value in expanding law enforcement authority, which could shift the court's approach dramatically. Chapter 8. Trump administration enters the fight. The involvement of the Trump administration has added a surprising layer to this legal battle. In an unusual move, the court granted permission for the Trump DOJ to join oral arguments and speak in support of Montana. Their position could directly influence how the Supreme Court reshapes the standards for warrantless entry. The Trump DOJ filed an amicus brief backing Montana's justification for entering the home. They argued that the Fourth Amendment should not require probable cause during emergencies. Instead, they urged the court to adopt a lower standard based on overall reasonableness. They claim probable cause is only necessary when a warrant is being requested, not for quick police action. This reasoning would give officers broader power to enter homes without judicial oversight. In their view, officers should only need to act reasonably under the circumstances, not necessarily have hard evidence of a crime. If the court accepts this lower threshold, it could fundamentally weaken protections against government intrusion, not just for Trevor, but for every American. The Trump administration's stance has intensified the stakes, signaling that this case could reshape decades of constitutional doctrine on home privacy. Chapter 9. Your home is still your castle for now. The phrase "your home is your castle" means something in American law, or at least it used to. The Case versus Montana decision will test whether that principle still holds firm in the face of growing government power. The Fourth Amendment protects against unreasonable searches and seizures. Home entry without a warrant is only allowed under very narrow exceptions. If this case lowers the standard, police can enter based on feelings instead of facts. That threatens every homeowner, gun owner, and citizen who values privacy. A ruling in Montana's favor could open the floodgates for broader home entry practices. This is not paranoia, it is a precedent. If one man in Montana can lose his rights, then no home in America is truly safe from warrantless intrusion. Chapter 10. The stakes couldn't be higher. This case is not just about one shooting or one police decision. It's about the legal framework that governs every police interaction in your home, especially involving firearms. If the court rules narrowly, it could protect our rights. If it rules broadly, it could change everything. A clear, narrow ruling could reinforce the 9-0 Caniglia precedent. A broad ruling could weaken the Fourth Amendment for years to come. Lower courts would follow this decision, influencing every future police encounter. Firearm confiscation laws could expand under emergency pretenses. This case could set the tone for how much privacy we truly have. The stakes are not hypothetical. They are real, immediate, and deeply personal. Every gun owner and freedom-loving American should be paying attention right now. Stay alert, stay informed. This is a moment that will define how much freedom we actually have in our own homes. The Case versus Montana ruling could either reinforce your right to be secure in your home, or it could give law enforcement more power to seize firearms without warning, evidence, or warrants, so you can protect yourself, your family, and your future. Subscribe to the channel, leave a comment below, and share this video with others who need to know what is happening. Because if we do not stay informed, we might wake up one day in a country where the Constitution no longer protects us, especially in the one place it always should, our homes.